Right from the start, you can feel the tension building in this courtroom. The judge is confirming charges, but what makes this moment critical is the plea decision coming next. In criminal court, a defendant usually has clear choices, guilty or not guilty. But sometimes defendants try to enter something called a no contest plea, which means they don't admit guilt but accept the punishment. The twist? Judges don't always have to accept it. And as you'll see in a moment, this judge is not playing around. Eyes.
Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
We are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 3059.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Okay.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Okay.
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no contest because he never even went over the indictment with me.
I find that hard to believe. So here's the thing.
Actually, be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
He was pitching over here.
Yeah.
So
The judge just lays out the legal reality. If the defendant rejects the plea deal and goes to trial, the state can pursue a habitual offender enhancement. That means instead of a negotiated sentence, he could face 25 years to life in prison. And here's the tension: the defendant keeps pushing back, while the judge is trying to keep the courtroom moving forward. This is one of those moments where attitude in court can seriously impact the outcome. So the question is he about to take the deal, or risk everything at trial?
the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment.
Sir, the allegation.
That's why I'm pleading no contest.
I'm not going to allow.
I'm guilty. It's fine.
Here's the thing. I don't have to accept any plea agreement.
Yes, ma'am.
Okay. So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games, and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty. Yeah. That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. You saying assault family violence. The evading arrest is guilty.
It's evading arrest or detention with the use.
I'm saying.
I'm looking at your indictment.
He's saying you got indicted for.
I got that.
For evading. In 2014, you were
Hold
convicted
on.
of something else. Okay.
You've probably already tried. Let me take care of it this way. Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not? You plead guilty or not guilty?
So if I'm telling you no contest, what is that?
It's nothing, and it's nothing. You're not allowed. I can take a plea of no contest, or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty.
I'm saying.
Period. I'm about to set your case for trial.
That's basically saying that I'm.
We're not going to argue the law.
I'm not, or I'm guilty.
We're not arguing the law.
That's basically just saying that I state that.
I'm not going to argue the law with you.
Guilty. Just sign. Go ahead. That's guilty. Go ahead. That's what y'all want anyway.
Listen,
I'm cool, man. Just go ahead.
Well, you're not. You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me
nothing here.
Plead guilty. There you go.
So you plead guilty to evading arrest or detention with the use of a vehicle. Okay. The next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction on your record? Okay.
And that's not the same
That's
case
okay.
as far as evading arrest, man. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
exactly. And listen, so Mr. Campbell, wow.
I thank you.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay. So I have let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
I'm pleading no contest, but guilty not.
So are you pleading guilty to this charge?
Yeah.
Okay. And did anybody force you to plead guilty in cause number 22-39050?
We just answered it, man.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
I just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it down.
No, I think you did. You did, but let's go. So no.
Okay. So I have in both of those cases here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go?
After all that back and forth, the courtroom finally reaches the moment that matters most, sentencing. Despite the tension, the defendant ultimately accepts the plea deal. And legally speaking, this is actually far better than the risk he was facing. Remember, the judge already warned him that going to trial could have meant 25 years to life. Instead, the agreement caps the sentence at 18 years, with both cases running concurrently. But here's the real question for you watching this. Did the judge handle this situation the right way? Or did the courtroom exchange escalate more than it needed to? Let me know what you think in the comments.
Over them with Mr. Parker. The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
What we signed the documents.
Okay. You have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed. Okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal, and get out. You're making this way more difficult than it has to be. State tenders number one in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're good.
You said
I just printed the wrong thing.
She asked me if I thought that there's evidence you weren't. I said, no, there's not. He's confident.
All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, fell, please. I ain't drinking.
Mr. Campbell, you ready?
Yeah.
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the record.
No, I'm saying say that how long I've been in custody.
I don't know. I don't have that information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it at the jail. No.
Excuse me?
No, they have it at the jail. No.
Good morning. You're Mark Garcia.
Yes, ma'am.
And Mr. Garcia, calls number 25 DCCR 0120. You were previously in court. You entered a plea of guilty to theft of material, aluminum, bronze, copper, or brass, a state jail felony, and that was a cap of 16 months in the state jail prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have to.
I do, Judge. Are there any additions or corrections?
Yes.
Explanations?
Yes, there is one issue that we would like to address regarding his statement.
Okay.
And Judge, that was in regards to his description of what happened as far as when he talks about them not stealing the copper. I think that was more of an issue of course, him not admitting that they were caught in the act. And this was something that was after the fact. He was stealing the truck. He understands, how that may have sounded the way he expressed himself, and he totally takes responsibility for it.
So, Mr. Garcia, you said specifically in quotes, we did not steal anything from there.
We didn't, but we were caught there. We shouldn't have been there in the first place. I accept responsibility for what we were doing.
Well, what were you doing? What are you accepting responsibility for?
We showed up to look at the site. We were supposed to check it out. And that's when the cops showed up. I wasn't even in the, you know what I mean? I was there. I was in the truck when the cops pulled up, but I thought we were there on a job. Okay. So I thought we were supposed to be working, we were supposed to plan, but we hadn't yet. But I accept responsibility for what we're there to do. You know what I mean?
I don't know what you mean. That's why I'm asking you, because you're saying you were there in absolutely legit reason. And there was material in the back of your... Here's the thing. Now's the time not to gloss over it. Okay? Either you did it or you didn't do it.
Yes, ma'am, I did. That's why. But
that's not what you're saying. You're saying you went there to do a job, and the cops pulled up, and y'all just got in trouble, and you don't know why.
For 10 minutes. I mean, I don't know how else to put it in words. I did what I'm accused me of doing. I don't know how else to word it. She asked me to describe the situation. I did.
You said we did not steal anything from there. So did you or did you not steal
I did.
Okay. So that's not what you just told me.
I don't know how else to word it. I hadn't gone in yet. We hadn't, but I don't say.
But the stuff was in, you had cut copper, a reciprocating saw, drills, and tools in the immediate area, in addition to multiple bundles of copper in the back of the truck. So how, I don't still understand. Did you steal the copper or not?
Yes, ma'am.
So now let's go to your criminal history and the fact that this isn't your first time to do this. You've got 1, 2, 3, 4, 5 prior felony convictions. You've received the max of 2 years state jail on 2 of them. 1, possession of a controlled substance and fraudulent use or possession of identifying information. You've received a 1 year state jail on theft of material. You've received a 2-year term on possession of a controlled substance. What all that means to me is that the deal that you received going on count 1 only, you could have been looking at 2 to 10 instead of just a state jail. And I don't agree. I think after seeing this, Ms. Malfino, is there something else that you either did or didn't know that would go into the state's position on that offer?
Judge, only that in my review of those priors, there were two state jails that did not need to be sequential, so I would agree that it could be a 3rd degree. I totally understand the court's confusion with something less than is what the 2 years that he has already received, and if we need to revisit that under a 3rd degree.
There's no facts or issues. Is there any, I mean, I guess any underlying facts or issues with the case that?
Not particularly, Judge. I mean, I know some of the people that run the AT&T, and I know this is a very menacing type of offense that then leads everyone else's bill to increase because we're all paying for what they're doing, but nothing particular because of this offense, Judge.
Okay, then I'm not going to accept that that agreement. It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue.
And Judge, just to kind of point out there, mitigating circumstances for us. Mr. Garcia, he was dealing with a drug habit. That even why he's in custody right now from testing positive when he came into court. He has been struggling with that, but he has done some things or to try to move himself from the surroundings he was in, even while the case was pending.
I appreciate all that, but there doesn't seem any reason for me at all to agree to a 16-month sentence when this is his 6th felony offense, and it's the same type of offense. And the last time he was enhanced, or it was at least a 2-year in prison, in TDC, not state jail. He's looking at 2 to 10 if he went to a jury, and I don't think 16 months is appropriate at all. I don't think that's what a jury in our community would think was appropriate for someone who continues to, y'all go talk about it if you want to. I can reset it and you guys can kind of renegotiate and look at it and let me know. But at this point, I'm going to reject that offer.
Okay.